All right, everybody, welcome to the library. Sorry for the late start. You know, sometimes things happen. We just go with it. But thank you for coming this Tuesday evening. Happy to have you here at the library. I'm Lauren Gramley. I'm the business specialist. I'm basically here at the library with a lot of great databases, resources for small businesses and nonprofits. You can do one-on-one consultations with me, the business specialist. We also have a lot of amazing workshops with local experts like Julie King. And so I'm going to go ahead and give a quick little intro of Julie King. She's the founding attorney of King Patent and Business Law, a local law firm with nationwide practice focusing on patents, trademarks, copyrights, and business transactions, especially those related to intellectual property like licensing, assignments, and more. Julie is a registered patent attorney focusing on consumer products, equipment, software, computer hardware, business processes, mechanical sciences, using her background in computer science and physics to guide her clients to successful registration. She's also a seasoned trademark attorney, counseling clients about branding and helping them protect their trademarks. She regularly helps local entrepreneurs start their businesses and address ongoing operational issues like contracts, leases, and handling the changes that growth requires. Julie's a CU native who left to practice in Knoxville, Chicago, and Atlanta before returning home to start her firm. She loves being here again and working with the outstanding local business community and in leadership roles in the local bar association and women's networking groups. So let's welcome Julie King.
Thanks, Lauren, and thank you all for coming out tonight. I have a presentation that's probably a little too long, so to help it be a little less long, just going to do a quick survey. How many of you have already started a business? Okay, so a handful, and the rest of you are thinking about it or just curious? Okay, if you didn't pick up one of the little orange neon things in the back, that has a QR code and the URL to a website that has the slides with the notes. So there's gonna be a lot. There's probably no way you can write it all down or remember it. So if you get that, you can have access to the full presentation, read it online if you want, download it, print it, whatever. So we're going to talk first about the various business structures and what they're about and why some might be more appropriate in situations than others. And then we'll move on and talk about the impact of intellectual property on businesses, because every single business has intellectual property, whether they're aware of that or not. Whoops. Come on. Okay. I do have to make note, this presentation is for educational and entertainment purposes only. It's not intended as legal advice specific to you, and it does not create an attorney-client relationship. This presentation does not make me your lawyer. I strongly recommend the next step be consulting with a business attorney and an intellectual property attorney for assistance with these subjects. This presentation can help you understand some basic concept and get you prepared to talk with an attorney about them and give you some information about DIY ways to do things, but it's not intended to give you all those necessary tools or advice to handle your business or intellectual property needs by yourself or using an online service. This presentation is really intended for the kind of small businesses most people start, which just have a few owners, maybe 1, 2, 5, probably not 10, maybe just a handful of employees. When those grow into much larger businesses, you need to consult with a business attorney who handles more complicated structures and finances, as well as an employment attorney. And it's at that point that you may decide that rather than working with a solo attorney like me that has very specific areas that I practice in, that a firm with multiple lawyers with expertise in many areas becomes more appropriate. So these are some of the things we're going to talk about. Naming your business, choosing what business entity and you want to be and how the documents you need to do that. Talking about tax status that you can select, what operating documents you need, additional licenses, registrations, setting up separate bank accounts to keep liability limited, the new Corporate Transparency Act reporting, Going to touch on employees and website legal issues, transferring assets to your business, real briefly on insurance, and then protecting your intellectual property. So the first thing is naming your business. It's one of the most important things you can do about the business because it's how the public knows your business, and it's incredibly easy to get this wrong. And when you get it wrong, it's not just that people might not know what your business is or be able to distinguish it from others. It's that you may be forced to rename your business in a way that's inconvenient for your schedule and possibly pay someone some money damages if your name is infringing on someone else's trademark. So the best thing to do when you're thinking about naming your business is talk with a trademark attorney. If you've already started the business and named it, you can still deal with these issues. The sooner the better, because if you find out before the person you're infringing on finds out, you can quietly go about rebranding without alerting them and probably avoid any kind of cease and desist letter and getting sued for damages, because nobody wants to get sued for damages. The reason I recommend working with a trademark attorney on this is there's a lot of nuance in clearing a name for use. And what clearing a name means is that we make sure that no one else has a business or maybe a product line or something like that with that identical name or something very similar, something that might be spelled similarly, sound similar, have an identical or similar meaning for identical or similar goods and services. Now, if you have like a line of baby clothing and you've got a name you want and we do a search and we find out that someone selling automotive parts has the same name. The standard in trademarks is it likely to confuse the average consumer of those goods and services? And that sounds pretty subjective, and it is. I kind of just, when I'm trying to decide, would this be confusing, I can get a little out of touch because I look at these things all day long. So I think about what would the average busy mom shopping at Walmart with her kids trying to pull something off the shelves while she's trying to grab the other one from running down the aisle, what would she think? Would she confuse those brands and think that the baby clothes were offered by the people making automotive parts? Even under those circumstances, probably not. So, it's not the lowest common denominator that we're worried about, it's the average person, and the average person wouldn't be confused by that. So you could go ahead and name your baby product business with that name, even though the automotive parts place had one with that. A lot of people get really confused, and this is totally understandable. When you register your business with the Secretary of State, like you form your LLC or corporation, you file the documents, and it comes back and they've approved it. A lot of people think that means the name is clear and it's not possibly infringing on anyone else's trademark. The thing is, the Secretary of State's office only checks their business database. Now, if someone else has a really similar or identical business name in Illinois, they'll stop you. They don't check their own trademark database, though. They don't check the federal trademark database for sure. And when I told a bunch of my business attorney friends about this a couple months ago, some of their jaws hit the floor and they're like, they don't what? So getting your name approved when you register your business is really not enough to make sure that you're not committing trademark infringement. Using a trademark lawyer to help you with this clearance search is, I'm not gonna lie, probably gonna be expensive, anywhere from several hundred to several $1,000s, but it's money well spent to avoid having to do that rebranding and maybe getting to have to pay someone some damages like I talked about. But if you truly can't afford a lawyer, and I know that a lot of people on startup budgets, that's just not in the budget, you can at least do these things. You can search both your state and trademark databases. In Illinois, those are online. You can search the United States Patent and Trademark Office's trademark database. It's online. It's got a new interface that is less easy to use, but it looks nicer. They have a great help function. that can help you. Don't just type stuff into the search bar because you're going to get misleading results. Use the help function to help you figure out how to make it so that you don't get like 50,000 results to comb through, because I don't do that. So, and then just do your basic Google search. Google's a really great way to see if someone's using a name but they haven't registered it with the state of Illinois or federally. If you find one that's just overseas, doesn't have a presence in the United States, if you're not planning to operate overseas, that's fine. And when you do search, do it with some variations, like alter the spelling a little bit, truncate it, to do iterations of a word, things like that. Search things maybe similar meaning or that sound alike, just so it's a little bit more concise. You might also want to search social media. That's part of what I search when I do a search. When you form a business, you may not want to do business with the public with the same name that you officially named your business. And if you're a sole proprietorship or general partnership, this is particularly important. If you are a sole proprietorship or general partnership, you have to register your assumed name, and it's also called DBA for doing business as, with the county and the county clerk's office. And you have to publish it in the newspaper a few times, and they'll walk you through how to do all of that. If you have the kind of business that you must register with the Secretary of State to form, you have to register your assumed name with them, and of course, both of those things cost money. More importantly, once you get that done, is when you're signing legal documents, always sign the documents with both the official name and assumed name. So if the business's official name is Robert's Restaurant Incorporated, but they're doing business as Bob's Burgers, when they sign like a lease or a loan document, they're going to sign it Robert's Restaurant Inc., DBA Bob's Burgers. The next huge thing to think about after you've decided on a name is choosing your entity. In Illinois, we have 4 kinds of entity categories. A sole proprietorship is one person operating the business with no separate legal structure. It provides no liability protection to the person beyond what insurance might cover. If there's more than one owner, then it becomes a general partnership, which is also not a truly separate legal entity regarding liabilities. A partnership is a formal or informal agreement between 2 or more people to operate as a partnership, and that has certain tax and liability consequences. In Illinois, we have general partnerships, limited partnerships, and limited liability partnerships. The next step up the chain, basically, with liability is a limited liability company, or LLC, as a lot of people call them. That's a formal separate legal entity, and it does shield the owners from business liabilities when it's operated properly. But it has a less rigid structure than a corporation, more available taxation options, and has fewer paperwork and formal meeting requirements than a corporation. Some professions in Illinois must be professional limited liabilities and limited liability companies, and that's something you can look up, and I'll give you the website for that in just a bit. The corporation is the last formal separate legal entity, and it shields, again, the owners from liability when it's operated properly. It's best for larger businesses or businesses with investors who want that formal structure. I've worked with some people at the research park, and they started off as LLCs. Well, when they started to get these angel investors, the angel investors wanted them to change to be a corporation because they wanted the more rigid, formal structure of the corporation, and that was something they were more familiar with. So I worked with them to change the business structure, which is something you can do. The sooner you change business structure, the easier and less expensive it is, but at any time, you can change from one business structure to another. Oops. Nope. So just briefly, we're going to look at the liability protection that these offer. Again, sole proprietorships, no protection against business liabilities, which means that if you get sued for something, someone trips and falls in your store, and the insurance either doesn't cover it or the judgment claim gets above your insurance policy limits, you could lose your house, you could lose your retirement income. Nobody wants that. So I never encourage people to be a sole proprietorship, given that an LLC is really easy to form and operate. Partnerships, it's a mixed bag. General partners, which is like 2 people doing a sole proprietorship, again, no liability protection. If you have a limited partnership, managing partners, which are the ones who are involved in the day-to-day operations of the business, don't have any liability protection. The limited partners, who are essentially silent partners, do have the liability protection. And if you have a limited liability partnership, usually those are done by professional corporations, so say like a dentist's office. Each dentist will be shielded from some of the business liabilities. More importantly, though, they're shielded from the other partners' malpractice or wrongful acts. So if one of the dentists accidentally commits malpractice, gets a nasty judgment against them, none of the other partners in that limited liability partnership need to worry about that. LLC, way less complicated, you're covered. Corporation, same deal, you are covered against liabilities. Of course, that's if they're operated correctly, and I'll talk about that in a little bit. A lot of people ask me, should I form an LLC or corporation? So these days, most small businesses start as LLCs. And the reason for that is they have more taxation options. You can be taxed as a sole proprietorship or partnership, which means it's just straight pass through onto your income tax return. You can be taxed as an S Corp or a C Corp, and those are different ways of being taxed rather than self-employment. In the C Corp, that's double taxation. The business gets taxed, and then you get taxed on your income. LLCs have an operating agreement. Corporations have a stockholder agreement and bylaws, more paperwork. LLCs don't have meeting requirements. There's less record keeping. Corporations do have meeting requirements and a lot more record keeping. Not-for-profit corporations are a type of corporation, but they follow different rules than regular corporations. They don't have shareholders. They have directors, and you have to have at least 3. Which means you also don't have a shareholder agreement, you just have bylaws. Not all not-for-profit entities are charities. For example, our local bar association is a not-for-profit corporation, but we are not a charity, we're a professional organization. Also, not all not-for-profit corporations are automatically, well, none of them are tax exempt automatically. You have to apply for tax exemption at the state and federal level, and not all NFPs can be tax exempt. So we're talking about taxes, and selecting tax structure and getting your tax ID numbers is something that tends to start getting people really tense when they come into my office and talk to me. If you have an LLC or corporation, you have to select a taxation status. And a lot of that's going to depend on your personal financial situation, the projected income from the business, and a host of other things. It really doesn't make a lot of sense unless you're making a significant amount of money. This is something that you really want to talk about with your accountant, and you should have an accountant if you're going into business, and your financial planner if you have one, because they see your whole financial picture, and they're going to be able to give you better advice on which of these taxation statuses is best for you. You also have to obtain your federal and state tax ID numbers. And pretty much everybody except a sole proprietorship has to do that. Those are not as horribly difficult to get as people might think. Generally, you can get your IRS identification number in less than half an hour online, and it's fairly simple questions. The state of Illinois are more complicated, especially if you're in certain industries or you need to collect sales tax. All businesses created by registering with the Secretary of State also have to have a registered agent. And the registered agent is a person or business entity to whom all official correspondence from the Secretary of State is sent. It's also the person who's going to be served if you get slapped with a subpoena. or a lawsuit. They can't have a P.O. box address, though, and that trips up a lot of people because they don't necessarily want to have their home address out there for everybody to see, and they have their business behind a P.O. box. And that's fine. Sometimes you can weasel around it by using one of those UPS store addresses. Sometimes the state's wise to that, and sometimes they aren't. So sometimes people have their lawyer act as their registered agent. There are also companies that are in the registered agent business, and you can just pay them X amount of dollars per year, and they'll act as registered agent for you and let you know if you've ever been given documents that they need to give to you. And one of those is always going to be the annual report notice. Every business that registers with the Secretary of State has to file an annual report. That's not scary. I've heard people think it's like that investment prospectus you get when you invest. It's not. It's a 1 to 2 page form online, essentially. It lets you tell the state who the current owners are, if there are directors, who they are. Sometimes you have to tell who the officers are, and confirm or change your business address and a couple other things. Confirm the registered agent, that kind of thing. And you can change those under certain circumstances on the annual report. Other times you have to file additional forms, and of course, there's always fees. Anytime you file anything with the state of Illinois, there is a fee you are going to have to pay, because that's how Illinois rolls. So how do you form these various entities? Sole proprietorship or general partnership, you don't really have any formation documents, you just kind of do it. You might need to file that DBA with the county. If you have a partnership of any kind, general partnership, limited or limited liability. Oh, that's the next slide. Sorry. You do need a partnership agreement, and we'll talk about it next. For formation, the limited and limited liability partnerships do have documents that need to be filed with the Secretary of State, and also your DBA gets filed with the Secretary of State. LLCs, articles of organization, get filed with the Secretary of State, as does the DBA, if you need one. Same with corporation, articles of incorporation, filed with the Secretary of State, and so is a DBA if you need one. So you've got that done, and you're not good to go yet. You've got to have operating documents. You should have operating documents. They're not required, except corporations are required to have bylaws. It's really, really foolish if you are more than a one-person business not to have operating documents. And the reason for that is the operating documents are what set the blueprint for how your business is going to operate, not at the day-to-day level, but the bigger picture. Who are going to be the officers? What are their duties? How are profits and losses going to be allocated? When are you going to distribute profits and how? Who's going to make what decisions? What are you going to do when there's disagreement on those decisions? Who's going to vote on them? What kind of vote do you need for particular things? Do you need a unanimous vote, simple majority, supermajority? And there are a lot of really creative ways I've seen people handle how they're going to deal with any, like if they have a tie vote. Some people have actually put in, we're going to draw straws. We're going to roll dice. Some people have gotten way more formal, and they're like, we're going to consult this particular outside advisor, or we're going to have to go to mediation to do it. So it can be something kind of fun to decide your impasses, or it can get really serious, however you feel best handling it. It also talks about what happens when things don't go according to plan. What happens if someone needs to leave the business, who's an owner? What happens if they die? What happens if they need to be kicked out? It happens more often than you think. What happens when someone wants to join as an owner? So it covers all these things. So that's why it's so important to get these. And it covers what happens if the business needs to close. I have an example. You're going to pay a lawyer a whole lot more money to handle the things that go wrong that could have been prevented if you had a good operating document. And I know this from personal experience. I had two best friends form a business. They didn't form it through me. They got documents off the internet. that were insufficient and didn't talk about what to do when the business closed. They grew to hate each other, needed to close the business. It was ugly. It was really, really ugly. And the only people that came out ahead were me and the other lawyer. We made a lot of money off of that. And, we didn't feel good about it, but there was a lot of work for us to do. And they could have avoided all of that if they'd had a good operating document. So for partnerships, partnership agreement is what you do for your operating document. Corporations, bylaws, and stockholder agreement. And the bylaws are how it runs. The stockholder agreement covers all of the things that relate to ownership of the stock, more like the distributions and then dividends and that kind of thing. LLCs need an operating agreement if there's more than one person. If you're just a one-person business, if you're a corporation, you still have to have the bylaws, but the other things, if you have disagreements with yourself, that's a whole different thing, and the legal documents aren't going to help you with that. You need some other kind of assistance rather than legal. So you really don't have to have those. Now, sometimes a bank or when you're setting up bank accounts or a lender or a landlord or something like that may want to see these. So you may have to scramble at the last minute to get some of these. In a situation like that, like when you have to have one tomorrow, I'm not saying downloading one off the internet or paying like $20 for one is the worst thing in the world to do in that case. If you then follow it up with a good one, either created specifically for you by an attorney or one that is online, but at least costs a whole lot more, because with all this stuff, honest to God, you get what you pay for. Like I said, those ladies got a cheap one for free off the internet, and then they paid lawyers thousands because they cheaped out on the operating agreement. Some professions also need to get specific licenses from the state of Illinois. There's a website you go to find that. Champaign County also requires some additional licensing, like if you're going to sell liquor, but there are some other things too. Your cities and villages are probably going to have licenses. All of these are on their websites. If you have any game of chance in your business, even a charity fundraiser where you're selling raffle tickets, you have to get a gambling license from the state of Illinois. And if you don't, it can get a little ugly. Now, are they going to find out about it? Maybe, maybe not. Do you want to take the risk? You've got to set up separate bank accounts for the business. When you have a business entity that does limit your liability, if you don't keep your personal finances separate from the business finances, if you commingle those funds on a regular business and really don't treat it like a separate business entity, you can actually lose that liability protection that you worked to get. So, now every now and then PayPal's going to suck money out of the wrong account. It happens. You take the wrong card to the grocery store. As long as you keep careful records and reimburse whatever account needs to be reimbursed, you're going to be okay. That's not going to make you lose your status. Try not to do it often, but it's not going to be the worst thing. This is a new pain in the butt requirement from the government this year, and the burden falls on small business owners because large businesses don't have to do this. The point of this is allegedly to find more people who are laundering money and funding terrorists through small businesses. So almost all small businesses, and according to the government, like small businesses 500 employees and under, so that's still a pretty big business, has to file this new report online under the Corporate Transparency Act about beneficial ownership reporting. And they have to report everyone who's an owner of either over 25% of the business or who has significant control over the operations of the business. Businesses that start in 2024 and after also have to report the people who formed the business, which may sound like that's people in the business, and it might be if they did their own formation documents. It's actually the people who pressed the button to submit like your articles of incorporation. So like a paralegal directed by the attorney might have to be reported. So you can see why I think this is kind of a bit flaky. If you have an existing business that started before 2024, you have until the end of this year to report. If you formed this year, you have 90 days after formation to report. Next year, that dwindles to 30 days. For any of those businesses, if you have changes in any of the information that gets reported, and that includes like someone changing their home address, you have 30 days to report that. And if this sounds like a giant pain in the butt, it is. The fincen.gov website /BOI has a ton of really helpful information to help you figure out how to do this. Most attorneys are not filing these for their clients unless their clients just completely, oh my God, I can't do this, and yeah.
I was warned about this when I looked into it. That does not apply to sole proprietorships?
Correct. If your business is one that is formed by registering with the Secretary of State, you have to do this. Sole proprietorships and general partnerships don't. So you at least get let off the hook. If law firms are helping people file this, we often ask our clients to go ahead and fill out something on that website anyway, because we don't want to collect all your personal identification information and then be subject to all the laws of, storing that properly and transmitting it securely and all that. It's honestly just a bigger risk than we want to take on. And then we'll give you, if we form your business, a certain ID number that you can get for that site. And that way we don't have to give you our home address and our social security number and all that stuff that honestly, other than this, you don't really need. So this is a whole bunch of new fun. There are lawsuits trying to get this stopped. There are some people who are exempt from this. The exemptions are on the fincen.gov website. If you're going to have employees, basically, down from here, and these two are the most important things. Always, 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 always have contracts. Even if it's just for a one-off teeny little job, get it in writing. Everybody needs to be really clear what the parameters of the work are going to be, when payment is due, how it's going to be paid, all of those details. Another thing that's crucial is making sure you identify people correctly as W-2 employees or 1099 independent contractors. A lot of people want to avoid the hassles of dealing with collecting taxes and just be like, oh, I'll just treat them as an independent contractor. If you get that wrong and they should have been a W-2 employee, the state can fine the bejesus out of you. You don't want to have that, and they're cracking down on this. They've actually said they're on a mission to crack down. So you really don't want to mess with this. If you're not sure, talk with a business attorney or an employment attorney, and they can help you sort that out. There are some good things on the state of Illinois' Department of Labor website that can help you with that too. But there are actually serious guidelines as to what a certain type of employee will be or not. A good way to protect yourself: non-compete, non-circumvent, non-solicitation agreements. Check with an attorney or an employment lawyer, a business or an employment attorney. Non-competes are pretty much banned in Illinois unless people make at least $75,000 in a couple other situations, and that amount is rising each year. Same thing with non-solicitation agreements. Non-disclosure agreements are usually pretty good. You want to have handbooks, proper trainings, all your required posters, notices. You get a lot of emails and flyers. Send us $100 and we'll send you all the posters you need. Don't do it. It's free on the government websites, or maybe like $10. So if you start a business generally and you get flyers and mailings and emails from people asking for money for things, you can pretty well be assured that it is not real. And you don't have to pay that. Make sure you get the right professional help, whatever kind of business attorney, employment attorney, CPA, some bookkeeping. You got a website, and most of us do. You have to have a privacy policy. You have to have terms of use, and you have to be Americans with Disabilities Act compliant, which means it has to be friendly for visually impaired people to use. And most people don't know this. And so there's things that you can do with, like the contrast between text and the background. There are plugins for WordPress that can help you figure this out. You can be fined pretty heavily. There are some people who just randomly sue businesses who aren't compliant. So it's kind of a big deal. Under certain circumstances, you may also need a cookie policy and a copyright policy. If you're going to transfer assets, say you've got a photography business and you've got all this photography equipment you own personally and you want the business to own it, you can make that as a capital contribution of equipment noted in the business books. You can sell personally owned assets to the business. Vehicles, you're going to need to transfer title. Ask a landlord to re-sign the lease as the business entity rather than personally, and that's got a lot to do with liability, although they often have you sign a personal guarantee, so there is that. Real property can be transferred by deed. You can lease it to the business if that makes more sense for you financially. Anything that's got a loan involved, you got to check with the financial institution because they have to know about it. It's going to be in the terms of the loan. They may work with you to do it. They may not approve it, so you can't always do it. Insurance, there's a lot of different kinds of insurance you might need. You should have some. Make sure you at least have a general liability policy, especially if you are a sole proprietor or general partnership, because without that, you, honest to God, could lose everything, and that is not why you went into business. If you sell things, you may need product liability. I have malpractice insurance, as most lawyers do. These are all various kinds of insurance that a business may need, you may not need. Sometimes by law, when you have employees, you have to have certain kinds of insurance. Talking with your insurance agent, if they're really good, is a great way to figure out what is going to suit your needs and your budget best. So I'm going to try to cover some intellectual property stuff really quick. I know we're kind of getting short on time, and I want to take some questions too. So I'm going to give this an even lighter gloss than I had planned, but feel free to ask questions afterwards. Every business has intellectual property because your name of your business is intellectual property. A bunch of other business assets are going to be intellectual property too, and we'll talk a little bit about that and how to protect those. There are sort of 4 or 5 main types of intellectual property. You've got patents for inventions, trademarks for things connected with branding, copyright for creative works, and the bar on creativity is, I mean, like this would count, and that's not like, it's not art. Trade secrets and confidential information are sort of part of the same beast. Trade secrets have particular laws that cover them, and confidential information is sort of a catch-all for things that aren't covered by the others, or maybe are, but aren't best protected under those laws. My favorite example is Netflix makes and markets a movie. What they're going to do is get a copyright for the film itself, for their marketing materials maybe, their promo photos, things like that. They're going to trademark the Netflix brand name, their slogan and their logo, probably the movie name, maybe some slogans, things like that. And then they have a patent on the streaming technology that brings the film into your home. So one little movie has a slew of intellectual property attached to it, and while that's a big deal production, even a small piece of business can have multiple aspects of intellectual property that need to be protected. Copyright, it covers creative works, and it has to be something tangible, either something you can present, record. It can't just be an idea, basically. Copyright lasts for the life of the author plus 70 years if the work was created after 1978. These kinds of things are covered by copyright law, printed materials, audiovisual materials, things we would consider typical artwork, drawings, paintings, photographs, live performances can be, sculpture, commercial works like this presentation, software programs, business plans, websites, things like that, all can be covered by copyright law and can be registered with copyright.gov, which is the website for the United States Copyright Office. Things that people think can be covered by copyright that are not. Your business name, no. Character names, titles, slogans, blah, blah, ideas. These are all covered under other parts of intellectual property law. Copyright registration, you have copyright in something the second it's created, that's limited rights. If you want to be able to sue people and get extra damages for infringement, you need to register with the Copyright Office within 3 months of basically releasing it to the public. If you don't register it that quickly, you can still sue people, but you're not going to get the extra money, and you're only going to get money that you actually lost, and that can be really hard to prove, and it might not even be worth the lawsuit. Initial business copyright issues to think about. You need to think about if there are existing copyrighted works that you're going to be using, and are they registered? If so, do you need to transfer ownership of the registration rights to the business, or are you going to license them from someone? If you've got works ongoing or that you're creating when you start the business, which ones are going to be worth applying to register? Now, you have to pay a fee every time you register something, and it gets expensive to register everything. So think about registering things that people are going to be likely to want to steal from you. You want to do really good record keeping of all your copyright rights. When you're buying a business, you need to think about who owns the copyrights for that business. Are they individuals? Is it the business? Does it need to be transferred? Are you going to license them? And in franchising, you're going to use a lot of the franchise's copyrights in your marketing materials. And that franchise agreement is going to talk about whether material you create, you have the copyright to, or they do. And most likely, they're going to have the copyright because it's based on their intellectual property. Anytime you create original content, think about whether you want to register for copyright. When you are using someone else's work, I found it on the internet, so it must be free, is just not true. It's absolutely not true. Somebody made it. Somebody has those rights. Now, if it's got this public domain thing on Wikipedia or images or something, yeah, okay, you can use it. If you're using Canva, Adobe Photos, Getty Images, or you just see something cool on someone else's website and you're like, ooh, I want to put that in my flyer, find out who owns the rights, find out under what terms you're allowed to use it, and whether you have to pay them money. There are businesses, especially photographs, because the people who took those photographs belong to big organizations that will hunt you down and send you a cease and desist and a demand letter. And it's usually for a few $1,000s, and sometimes you can get it knocked down. And I had someone call me, and they run a nonprofit, and they took a photo that was on another nonprofit's website that they were trying to hype up and used it on their own website with no credit, and they didn't pay to use it, and they got slapped with a cease and desist. They had to take it down, and they ended up having to pay, I think, $1,000 to the copyright owner. And it was like, you committed copyright infringement. There's really, you can't weasel out of it. So again, I found it on the internet, so it must be free. Not true. Trademarks are related to your brand, the golden arches, the Starbucks logo, the brand names, anything that relates to your brand identity as a business, and every business has its brand identity. Again, you have common law rights, which are created the moment you create something that's related to branding. A lot of the really good rights, though, like the ability, again, to sue for extra damages, to do some other things that we'll talk about, you've got to register with either the state or the federal trademark offices. But unlike copyright, those don't expire as long as you use the mark and pay your renewal fees. Trademarks can be any of these things. The scent of Play-Doh is trademarked. So, yeah, that's like, ringtones have been trademarked. The MGM's Lion Roar is trademarked. The setup of an Apple store is a trademark. So it can be, the Tiffany packaging is a trademark. Tiffany blue is a trademark. Home Depot orange is a trademark. The standard for whether or not trademark infringement is happening. And so when you're creating materials that fall under trademark, you need to think about this. It's that likelihood of confusion among the average consumer in the area of goods. Grubhub and Home Chef, unsurprisingly, are in a massive, many, many years going lawsuit trying to figure out who wins, because they're both in the home food delivery business. And I mean, looks pretty similar to me, and if I'm in a hurry and I maybe don't recall quite, getting over the hill, to me, that's kind of a no-brainer, but there's a lot of nuance on who got it first. Can they coexist? Sometimes you can get a coexistence agreement with someone that allows both of you to continue using your trademarks because you've agreed that the people you're marketing to, it's gonna be fine. If you don't register your trademarks, or even do that comprehensive search that we talked about when you're naming your business or doing a DBA, you don't know if you really own the name to your business or product, and you may find out the hard way. Your rights may be restricted geographically. You may be limited if someone else comes along after you and you're only using it in Illinois and they come along and use it nationally. They'll be barred from using it in your area of Illinois, but you won't be able to then go out and use it nationally. If you register, there's public notice of your rights, either in the state or federal trademark database, which means that it's sort of imparted knowledge to people. You're supposed to be aware of those things. Again, you can't get extra money when you sue for infringement. You cannot use the R symbol unless it is a registered trademark, not even when you've applied. You can use the TM symbol, and you should. You should use it right away. Even if you don't plan to register, use TM because that tells the world you are serious about your trademark rights, whether you're going to apply for registration or not. Registered marks, you can register them also, once they're approved, with Customs and Border Protection. It helps them stop infringing goods from being imported. They can't stop everything, but they try. You're going to have difficulty fighting back against unfair takedown notices. And really, honestly, the worst thing is you don't know if you're going to be forced to rebrand on someone else's timeline. So things that don't count as registration include that, like we talked about, forming your business with the Secretary of State. It's not good enough. Same thing with the DBA. That's great that they approved those names, but that's not trademark registration, and that doesn't clear the name. Buying a domain name or getting a social media handle. Now, if you can get those that match your trademarks, that's a good indication that that mark probably it's not already in use by someone else. So that's a good thing. It's not proof. There might be someone using it all over the place, but they're not on social media and they don't have a website. So that's a good indicator that you're on the right path. It's not proof. If you try to get a domain name and social media handles and they're all taken already, that's a really good indication that you probably don't even need to do the big search and pay all extra money to do the big search. That's probably a good indication that someone else is using that mark and you need to go back to the drawing board. Trademark issues, again, naming your business. All this applies to logos and slogans. You've got to clear those as well. Same with naming products or services. When you are buying a business, you need to think about whether rights need to be licensed or transferred. I think it was one of the guys that owned Hooters had their trademarks registered to him as a person individually, and he licensed them to the business. Well, they ousted him. But he never transferred the trademark to the business, and they couldn't make him do it. So he's still making a nice amount of money licensing the Hooters trademarks to the business, and there's really not anything they can do about it. So when you're buying a business or you are creating trademarks for the business, think about if you want to own it as an individual and license it to the business, or if it's better if the business owns it itself. And you'll want to, sometimes you can buy a business and it looks like they own the trademark rights and they forgot to file the renewal and the rights expired. So you want to check on their registrations. If they say, we have these registrations, check to make sure they're still active. When you create material that would be applicable for registration, make a plan on when you're going to apply. When you work with marketing people and internal people, do a style guide for consistency, because if you don't use your marks consistently, if you start changing the font sometimes or the color or the spelling or the drawing of something, you actually can lose the rights and have to start all over again. Franchises, you use their trademarks, you don't have rights to them. Patents are for inventions. They allow you to prevent others from using, making, selling, or importing the invention into the US. If you don't properly protect your inventions, and that's not always something that you do through patents, you lose your exclusive rights to make and sell the invention. Investors might not be so happy. If you disclose your invention to the public, you have 12 months to file your patent application, period. That's it. 13 months, no patent for you. So, non-disclosure agreements are your best friend for patent invention protection. You use them with everyone you want to talk about the invention with, because that makes sure it's not being disclosed to the public. And if they leak it or try to patent it themselves, you have some legal teeth to take them to court over it. If you have products manufactured overseas, you will get ripped off, especially if you have them made in China. Now, if you have a patent, again, customs can try to stop the import of the infringing material. They can't get it all. But if it's going to be ripped off and sold in China, there's nothing you can do about it unless you also have a patent in China, which you can get. Enforcing your patent rights overseas is generally something only larger businesses can afford to do. And even they, as you all know, as consumers of all kinds of public goods, and you see knockoffs all the time, even they can't really stop it. They do their best to stop the hemorrhaging. But, you know, patents are great in the US. When overseas gets involved, it's a little scarier. Again, non-disclosure agreements are your #1 tool for protecting inventions. Patents are great. Patents give you exclusive rights for up to 20 years for utility patents, which is for how something works. For design patents, which are for how something looks, that's 15 years. Other inventions may be better handled as a trade secret. We'll talk about that in a minute. There are also plant patents, but unless you're a botanist, you don't really need to worry about that. These are the things you cannot get a patent for. Abstract ideas, basic science principles and math formulas, and natural phenomena. The reasoning is that those belong to everyone, and it would be against the general good for anyone to be able to patent those things. So I mentioned trade secrets and confidential information. Protecting intellectual property that you maybe could protect through another way of registering something like the patent, or it can't be, but it does need protection. Trade secrets are sort of your core business information that if someone else found out about it, it could be harmful to your business. Proprietary and confidential information is a little less serious than that, but it's like your vendor lists and marketing plans and things like that, but you still don't want them to get out. The best way to protect these, limit access. If someone in your company or outside doesn't need to know about it, don't let them know about it. Don't let them have access to the room the files are stored in. Train your employees about how to properly handle and protect your intellectual property. Basic things like security, locked cabinets, locked room, encrypted clouds, security cameras, stuff like that. Don't overlook the physical security as a great way to protect some of your intellectual property. Keep excellent records about all of your intellectual property, because that's going to help you if you ever want to sell your business, having those great records. If you ever need to prove when you created something or who created it, any sort of chain of title for it. Inventors should keep notebooks documenting their process, style guides to make sure, again, that you've got consistent use. So this is where you might save some money and you might not. Do you need a lawyer for these things? Copyright, honestly, no. The copyright.gov website is designed for people to not need attorneys to register. And that's because a lot of prolific creators, like professional photographers, they couldn't possibly afford to hire an attorney to register all that for them all the time. Trademark and patent are a different story. There's a lot of nuance in those areas of law. And yes, some people register them on their own and it works just fine. That's great. The problem is you don't know what you don't know. And there are thousands and thousands of applications that as soon as they get assigned to an examiner, and that doesn't happen till like 10 months after you've submitted your application, are going to get tossed so fast, and there's no way of fixing them even with an attorney's help. The USPTO strongly recommends hiring an attorney, says it probably will save you money in the long run. If you are hiring an attorney to help you, don't go for the bargain basement attorneys. Again, you get what you pay for. You don't need to go for the super high, fancy, big law firm either. There's a wide range of trademark attorneys for everyone's budget and needs. Patents, yes, some inventors do it on their own just fine. However, think about that patent attorneys and agents have to have a special background and take a different bar exam to even be allowed to help people with patents. So that should give you an idea of how complex patents are. And they are written in this language that is not legal writing and it's not technical writing. It's like a Frankenstein's monster of those two. When you're going to hire a lawyer for any of those things, hire an intellectual property attorney. Do not have your divorce attorney do it. Don't have the guy who helped close on your house do it. Even if they say they can, you want someone who regularly does these things because, like any field of law, it's very technical and you want someone who knows the nuances and is going to make that process as successful and easy as possible for you. LegalZoom, things like that. I'm going to probably get like, if they find this, be like, oh, slander, libel. Yeah, okay, I've got a story for them. Don't. It's not worth the money. They lure you in with a tiny fee, and then they say, oh, we offer attorney assistance. And then you pay a lot more, and honest to God, it's usually crap. You would be better off not giving them a cent and doing it yourself with a little bit of effort for education. There are materials out there that if you truly can't afford an attorney, don't waste money on this. You can find a lot of things out for free and take your chances. And at least at that point, if you filed something and it gets refused, it's probably at least in shape that it can be fixed by an attorney. Again, the USPTO has something specific on their website talking about when do you need an attorney, and they specifically say they do not endorse the use of these filing companies. And I've got a story about that real quick. I had a client, and I'm changing some of the details here. She has a restaurant, and she's looking to sell products in grocery stores and also puts the name on hats and shirts. So she went through LegalZoom, and she got their attorney's assistant. And so this was about $800. And I know trademark attorneys that'll do the whole thing for $800 because they have a high volume, low cost thing. That is not my model, but to each their own. So they ran an artificial intelligence search on the trademark for him. Didn't explain any of the results. She didn't feel comfortable at all with what they were telling her. So they looked at what she was doing and they said, okay, you should definitely register for the stuff you want to put in the grocery stores, which was true. That was correct advice. They said, you should also register for the hats and the shirts, which was really bad advice because when you have something on a hat or a shirt or anything else like that, that's called ornamental use and it doesn't count. It has to be on the label or a tag, like a store tag or something like that. If you have a shirt with your brand name on it and it says Russell Athletic in the back, that does not count as working as a trademark. And they didn't tell her that. So the worst thing though, and keep in mind, this woman is in the restaurant business. They did not advise her to register for trademark protection for the core piece of her business, which was restaurant services. So this is why attorneys are like, honest to God, don't waste your money. There are other resources, and some of them, copyright.gov, beautiful, fabulous, detailed, but easy to understand resources. If you get confused and don't want to deal with it, then you can hire an attorney. But really, copyright.gov is great for DIY. USPTO.gov, tons of information about trademarks and patents. If you're willing to spend the time, you can learn a lot. And some lawyers often offer online courses. I have a few. There are others out there. Good books are out there, like the ones from Nolo, I recommend those. Those are written by attorneys, they are up to date, they're not gonna give you crap advice, and they're affordable. Yeah, I mean, they're great. They're really, really good. I recommend them. There might be a law clinic at the law school near you that can help you. There are patent and trademark. I think this one has a trademark clinic, I think, or used to.
There's a First Amendment clinic, I'm not sure.
I don't know, but at some point they had a trademark clinic. I know there's a school in Indiana that has a patent clinic. Volunteer lawyers for the arts, if you're in the creative field, can hook you up with an attorney for low cost or free. Might take a while, but they do have that service. The USPTO has an assistance program for DIY people. Not everybody qualifies, but you might, and so that's something to consider. So that is a super quick rundown of all of those things about forming a business, protecting your business assets, protecting your intellectual property. It's a basic start. There is a sheet in the back with a ton of QR codes on it. That is links to places on my websites where I have booklets and handouts and things like that to discuss some of these things in greater detail. They're free. I highly recommend checking them out if you're curious about more of these topics. And I would love to connect with you. I've got to sign up for an email list back there. We've got the little orange things that have the slides and a whole bunch of stuff I didn't get to say because I had too much on there. So there'll be more information in the slides that is in the QR code than I was able to present today. And I think, do we have time for questions?
Yeah, I mean, people that you're willing to stay.
Yeah, okay. Yes?
If I had like an LLC or a corporation, like 3-4 years that's been dissolved, is there any way to get that back up and running without a lot of payments?
See, I was about to say yes, but then you said without a lot of payments. So his question was, if he has an LLC or a corporation and it was dissolved, is there a way to get it back alive without having to pay a lot of money? Not really. The way you can revive those is paying like all the years of annual reports that didn't get filed, things like that. So that does get, the filing fees for those are anywhere from $75 to a few $100s every year, so that will add up if it's been multiple years. It can be done, but you do have to pay those back things. Sometimes, if it's been more than 3 years, that name sort of gets released back into the wild, and it may be easier just to restart another business. Mm-hmm. Yes?
So you were talking earlier about like starting, separating your finances.
Yeah.
Which makes, so I started a sole proprietorship.
Okay.
So, I mean,
And you're going to be an LLC or corporation now, right?
yeah.
Yes!
I mean, I'm a dance teacher for hire. You have the
Okay.
deal in like historical dance forms, and you give me money, I go call the ball for the
Okay, yeah.
for the Bridgerton ball or the whatever.
Oh, fun.
And but this is, I mean, it's a slow process.
Yeah.
And I'm selling a service nationwide to history museums all over the place. It means that right now I'm spending $1,000 for a table at this museum's conference and $2,000 for that museum's conference to have a table to sell myself. So I would say on average I am spending $2,000 to $3,000 a month in marketing and sales.
Okay.
And maybe I'm making $1,000 a month when I'm lucky because I'm new and first everybody has to know who you are.
Yep.
So, this is all coming out of my pocket, so I haven't made a separate checking account to have
Right.
a negative balance,
So
is this a matter of timing, or should I be setting up an account and just dumping $5,000 a month into it so that someday I stop hemorrhaging?
if you were already an LLC or corporation, I would say you have to have a separate bank account because those get separate tax ID numbers. And you need to have the separation for the liability things. As a sole proprietor, because that's all going to be passed through on taxes, right now, keep just really great records of your business expenses because you'll want to have those at tax time. And maybe when things start to take off more, that's when it makes sense to spend the money and time to become an LLC or a corporation. In the meantime, without that liability protection,
I've got a general liability policy.
great. I was going to say, just talk to your insurance agent and make sure you're well covered in the meantime.
Yeah, I mean, I've been, even though it didn't matter, I'm a doctor's wife, so it didn't matter. Now I filed for divorce, so I have to be more careful. But having that, because I've been teaching, everywhere I go, I start another dance group. And so my teaching a dance group, while it's just getting started, I've had general liability coverage for
Okay,
a
good.
decade at least.
That's good, yeah.
But
Okay, but yeah, it probably when you do get more known and you're starting to make more of a profit and your expenses are getting bigger and just everything becomes more complicated and your liability is greater, that's when it would make sense for you to switch over.
separate out.
Yeah.
So until then, it really doesn't matter that
Well, like you said, I mean, right now it's just hemorrhaging money, so why have a separate account? Because you don't have to as a sole proprietor.
Okay.
If you had the separate liability blocking entity, those do have to have separate accounts.
Okay,
So.
thank you.
Yes.
With,
Oh, sorry.
with visual arts and copyright, there's a certain date, there's a certain date where things are usually public domain.
Right.
But if something is very old, but a major work of art, say like the Mona Lisa or, something way old, but a major work, does it fall under copyright if you're doing something derivative?
Generally, for something like that, I don't think anybody, I am not an expert in copyright law, I will tell you that right now. I'm focused mostly on trademarks and patents. I do some copyright law. Mona Lisa is most likely in public domain. Certainly derivative works would be. There may be people who own copyright to derivative works based on that. Like maybe if Andy Warhol did a version, although he just got in big trouble with somebody, his estate did. Might have been the Campbell Soup people. It wasn't derivative enough just to do different colors. So things that are in the public domain like that, even though it's hanging in the Louvre owns it, but that's the physical owning, and the copyright is,
Even something is major, if it's old enough and far enough.
Yeah, so for example, Steamboat Willie from Walt Disney is now in the public domain. Winnie the Pooh, the character originally, is in public domain, and that is why you are seeing horror movies based on these characters. Our beloved little childhood characters are now coming after you with a chainsaw because they're in the public domain and anyone can use them. And that's why Disney makes changes to Mickey every now and then, because that extends, they say they've lost the copyright to original Mickey and Steamboat Willie, but 2003 version of Mickey Mouse, they'll own that for 70 years, after, So that's why you see things get changed like that over time.
Yeah, so you mentioned that you want or disclosure agreements, and that if something, you want to patent something, you have 12 months to do. So like if you just had a conversation with your friend about something,
Yeah,
that would start the clock
it could.
if she made it public or something, but not necessarily if a big stay between us.
Yeah.
Can you do a non-disclosure after that?
Yeah. I mean, if she hasn't blabbed yet, and yeah, she's your friend and it's a little awkward, but, if you've got that good of an idea, yeah, have her sign one. And it doesn't have to be super complicated, but I sell reusable ones for people, and they can just use it with, and a lot of attorneys do that too. There's probably some online that are decent. So, yeah.
And on intellectual property, if, for example, I've taken a class and the instructor is like, oh, go ahead and use my form. Like,
It'd be nice if they put that in writing.
okay.
If they haven't, you could make a note in your class notes. They said on this date we can use this, and that, if they ever came after you, you could be like, you said this though, and I have it in my notes contemporaneously, and that could kind of help. But generally, if they say something like that, they don't care, and they're not going to be going after people. Yes, sir.
So
did a trademark. It's actually the one that's on the back of my hat. And it went in 2 months, 3 months later, they sent it back, said it was one similar to the one that I have. And
Yes.
here comes like 40 different lawyers, like just constantly hitting from the thing. I'm like, I don't know which one these guys pick. I don't know if this is
Yeah, and a lot of those probably are scams. I'm going to be putting up a free course. There's a link to somewhere on there with my courses. I'm going to be putting up a free course on trademark scams. A lot of things that you get in email or through the mail that are intimidating trademark things are actually scams, and they're just trying to get your money. So you can go on the USPTO's website, and there's some links in the text of this if you go on my website, that you can look at what some of the known scams are, and you can also call them and email something to them. And there's a special fraud email and hotline, and ask them if they think something is a scam or not, and report it to them if it is. Otherwise, you're probably best off having a consultation with an attorney to look at the specifics of it.
Well, I actually called their attorney. Her name is Bree Stevens, and talked to her for a while, and she tried as best as she could to, as far as she could actually go to actually like help me without me having to pay.
Yeah.
You know what I'm saying? And just like they wouldn't stop. Even some came through on their website, and I just like, I don't know.
So are they accusing you of infringement, or?
Well, they wanted to try to help me straighten the trademark.
Oh, yeah, those are usually scammers.
And I said, well,
Predatory, we are not allowed to do that. That is an ethical violation.
I was like, I knew this.
If I know you are in the market for legal services and I contact you and you didn't contact me, that's not okay.
It was like every day, all day.
Yeah, and honestly, some of these people pretend to be attorneys and they're not attorneys. Right now, there's about 2,000 applications, and I have a client that came to me with one of these. There was someone, and this is again, the online things just don't. She hired an attorney off of Fiverr, which should have been her first red flag, because no attorney worth hiring is on Fiverr, period. Just if you see one and they're legitimate, don't. There's a reason they're on Fiverr and not getting clients elsewhere. So this woman had stolen the identity of another lawyer who wasn't even a trademark lawyer but was a real lawyer, and was using that to file trademark applications for people. And oddly, the application she filed for my client was not terrible. It's like, actually, it wasn't a very complicated market, but it's on a hold right now at the trademark office, and it will get thrown out because there was fraud committed in the filing of the application, because the attorney wasn't an attorney. The person filing it committed fraud because they misrepresented themselves as an attorney when they filed it. So most of these people that are contacting you are not looking out for you. I hate to tell you that, but I kind of like to tell you that because I don't want you to get ripped off.
No, I didn't. I just kept
Yeah, just,
too many of these guys.
yeah, I mean, honest to God, the scams it's like whack-a-mole with these things. And they're getting better and better and better looking. Some of this stuff looks really official. They spoof the USPTO's phone number. Again, I'll have this on my website, and I'll put it up with the one from here, and it's got a lot of good things on recognizing trademark scams. Yeah,
She had a, she's using holding her hand.
oh, sorry.
Okay, no, please, I'll come up. Thank you, though.
No, go ahead.
Oh, all right.
Yeah.
Thank you, this has been really helpful. My company does several different things, and one piece of that is training and capacity building. So when you're talking about copyright, I had like a tiny panic attack because I was thinking about the number of different trainings that I might need to copyright. And
Yes.
content. Is that really just going to be the reality, or is there perhaps a way to, like if I put it under a larger initiative and trademark that?
Yeah, so copyright has what's called a collection of works, and I think you can have up to 10, and it's often used for like tracks on an album or something like that, but or it might be a collection of related blog posts, but something like that where you sort of have like an umbrella area of the training, and then you have these particular trainings under it. You could probably register that as a collection, and that is not nearly not nearly as expensive as registering them all individually.
Okay.
So that's,
Could I do that and then create something new to put it under, or would I need to?
you would have to then, so once you've filed something, it's sort of, that's it. It doesn't get updated, it doesn't get renewed and changed. So you'd have to do a separate filing for new things.
That's helpful.
Yeah, but this is again why the Copyright Office really encourages people to do DIY. Because if you had to hire an attorney for all of that, I mean, there goes all your profits. Because that would just boom, boom, boom. So I really recommend going to their website. They have great materials on that. And if it gets too confusing, just shoot me an email.
I'm an author, and I've been on the copyright thing for years. It's so easy.
Yeah.
I mean, my oldest ones are actually handwritten and all that kind of stuff.
Yeah.
But it's so easy.
I mean, the filing interface is kind of old and ugly, but it works. And it's pretty straightforward. Like, it ain't broke, so they didn't fix it.
Oh, no, I appreciate it.
Who else has questions? Yeah.
Mine was, do you do employment law? Because I'm kind of confused.
I
between
am not
business
an employment attorney, so what I do for employment stuff is very, very limited basic employment law. I can help you figure out basic things about W-2 versus 1099. An employment lawyer is probably a better bet, because if there's any subtleties to it, they're gonna know those more than just a straight up business attorney would. So that said, I have reviewed severance agreements and contracts for independent contractors, created independent contractor contracts, that kind of thing. But if you are going to start to have multiple employees and you really need to start paying a lot of attention to things that apply to you legally when you have more than a few employees, you really want to talk to an employment attorney.
I don't have any employees yet.
So you're okay. Like, you don't have, there's a bunch of stuff you don't have to do right now.
I'm in massage therapy. and
Okay.
I was just at a conference and they told me that massage therapists in Illinois can't hire other massage therapists
Oh, interesting.
as independent contractors.
Oh, yes. And probably why that is because, well, I don't know that that's entirely true. Beginning, I'm not in employment. A lot of it has to do with if you are directing where, when, and how somebody does a job and you're providing the equipment for them, yes, they're likely a W-2 employee and not an independent contractor. An independent contractor is really, you focus on the independent part of it. If you have told someone, I need this to be done and sort of by this date, and it's up to them how they're going to do it and when they're going to work on it, and they're bringing their own materials to do it, then they're an independent contractor. So a lot of it has to do with how much control you have over how and when they're working. So I'm not sure where the massage therapist stuff falls on that.
Yeah, because that was just confusing, because I've worked as an independent contractor for a lot of people.
Yeah, that's, I'm like, oh,
Chiros,
there may be a special regulation about massage therapists. I mean, that's always possible.
so that would be a question for an employee.
Yeah. You can also look up some of this stuff on the Illinois Department of Financial and Professional Regulation, IDFPR, yes, website, and they have some information about stuff like that. So, as well as things like certificates and licenses and stuff. Yes.
So I just looked up the Champaign County Clerk's Office on doing a DBA information. It's like, since I'm in a sole proprietorship using my own name, but I've been, my YouTube channel and everything else, and my trademark that I'm trying to get is for History is My Playground, for the YouTube channel, and it's like, I should probably be getting a DBA for
Yes.
that. So here are the steps for filing your certificate. Fill out the assumed domain applications here, pay the $5 filing fee here, then it says, contact the local newspaper to run the required ad.
Yes.
Once you run the ad, newspaper will send you affidavit of publication. What's the
So,
required ad mean?
fortunately, you don't have to really know that. The News Gazette does this all the time. So you just call the News Gazette's ad department and say, or you can email them. I think they have an email address on their website and say, I need to do the DBA ad thing. And they'll collect the information from you and tell you how much it costs and tell you what schedule they'll run it on and when it'll be done and give you the proof that you've done it. So, yeah, they
My EIN is the same way. And it went through the news, said it's like 3 weeks, and then they will let you know, and I went to the Brookings building and got all my paperwork and all that.
So the EIN would be something you'd get from the IRS. Yeah.
Fill that out. And
Yeah, but
you have to run it. They had made me run it. I'm like, what are you talking
must have been something else, because you don't have to,
about? My name, and yeah, they made me do it all.
oh, the DBA, yeah, so the DBA has to, yep. It's like the town crier, like calling the banns for marriage 3 times before you're allowed to do it. It's a little goofy, but I guess it serves as because there's not a database that people can search, I guess technically this is the way of letting the public know someone's planning to use this name, and if you have a problem with it, you better speak up or forever hold your peace. Yes.
Yes, I have a question, and it's the legitimate question. So, you know, we've talked about like trying to keep the finances separate with a sole proprietorship, and especially with the other kinds of corporations, from the business expenses or the business-related transactions. Would it be enough to have the business credit card and make sure that everything is processed through that business credit card if all you're doing is making purchases and stuff at this point?
Not if you're an LLC or a corporation.
What if you're a single entity LLC?
You need to have a separate bank account with its own tax IDs and stuff, because it matters